Welcome to McDermott's 2021 Labor and Employment Legal Update. I'm Yesenia Gallegos, a partner in our employment group based in Los Angeles. In today's webinar, we'll discuss some of the major labor and employment changes expected in 2021. But before we dive into the agenda, allow me to introduce our speakers this afternoon, and this morning, I should say, depending on where you are in the country. And I'll also share a few logistical notes. If you have any questions during the webinar, please submit them using the Q&A feature, and we will address as many as we can before we conclude. We do have a robust agenda, so if we're unable to get to your questions, we will follow up with you directly. A link to the presentation recording and a copy of the slide deck will be available to you after the webinar. This program also offers CLE credit. It's important that you fill out the post-event survey that will be emailed to you in order to include your required information for CLE credit. For those of you in New York, I will read out a validation code later in the webinar that you should write down and enter into the post-event survey to secure your CLE credit in New York. So now, without further delay, let's get started. I'm joined today by Chris Brahm, a partner in our Los Angeles office. I almost referred to you, Chris, as an associate because he was recently promoted to partner, so yay, Chris. Alan Ronchetti, a partner in our San Francisco office. Elvira Cross, an associate in our Los Angeles office. And Kristen Michaels, a partner in our Chicago office. So I'll get started by sharing a roadmap on what we can expect to cover today. In terms of legislative updates and trends, for those of you who have not heard enough or had enough discussions about COVID-19, we will be discussing some regulations that will affect your companies in 2021 related to COVID-19 prevention and safety in the workplace. There are also new leave accommodations and mandatory reporting for employers. There's additional rules now with respect to administrative claims alleging wage claims or sexual harassment allegations. New rules for independent contractors and their classification, and rules affecting specific industries, and also rules surrounding diversity, equity, and inclusion. That's somewhat new. That's a trend that we haven't really seen through legislation in the past, at least in recent years. And we'll also talk about a few case law updates that may affect your policies and practices in the workplace. Next slide. Again, with respect to trends, I feel like every year we see similar trends. So increased employer obligations, including with respect to reporting requirements in 2021, more leave protections for employees, especially now surrounding the COVID-19 pandemic. We will see additional rules regarding meal and rest break and wage protections, increased diversity and equality requirements, as well as the counterpart to that, which is a federal restriction on diversity training, which may or may not continue to exist as of late January. So let's get started. Next slide. A few realities to begin with. We're starting to see the unemployment rate decline. Pre-COVID, we were at about 3.5%. In April of 2020, we went up to about 15%. And as of now, we're roughly at about 8%. I know that COVID cases have spiked again for a variety of reasons, including increased testing, but we're not sure how that's going to actually affect the unemployment rate this month. With respect to California alone, we're seeing an unemployment rate that fell below 10% for the first time just a week ago. We're continuing to see more and more employers adopt telecommuting, telework, which also means adopting new policies for those employees who are working from home. We're starting to see increases on payroll for companies who were originally hit the hardest. For example, hospitality, travel, retail companies, they're starting to bring back some of their employees. Government employment positions, as well as private education, is still lagging. They still remain affected by the pandemic, and we haven't seen any increases on payroll there. Next slide, please. So we hope that the takeaways that you will get from us today are what you'll need to do to update your employee handbooks or particularly standalone policies. We're going to be talking about some COVID-19 related policies that may be temporary. So you may not want to add them to your employee handbook, but rather create a separate standalone policy so that it is just a temporary policy until it's no longer required. And of course, you may want to consider training for your management level employees who will be, at the front lines and responsible for enforcing some of these new rules in 2021. Next slide. So I'm going to cover a few slides that really focus on diversity, equity, and inclusion. I want to cover a few trends that we're seeing and share those with you, and also cover requirements that may affect your particular company depending on your size and whether you're a private or public corporation. Next slide. So let's start with California's new pay data reporting law. It becomes effective March 31st, 2021, and it will continue every March 31st thereafter. This is going to apply to you if you're a private employer with 100 or more employees, who is required to file an annual employer information report, an EEO-1 report pursuant to federal law. So you'll keep doing what you've always done, but the difference is that now, for the first time, you'll be required to disclose the number of employees by race, ethnicity, and sex whose annual earnings fall within each of the particular pay bands. The purpose of this law is so that it enables the state of California to compile this data and to highlight pay inequities. For those of you who might remember, the Obama administration had put together a similar proposal that was ultimately struck down, but this California law really mirrors that prior now defunct proposal. So let's talk about the effects of this, seemingly innocuous employer reporting obligation. Next slide. We do have some concerns with this because the way your companies, if this applies to you, will be reporting this data is you're going to provide a snapshot of basically means any pay period of your choice between October 1st and December 31st of the reporting year. That snapshot will include the pay data that we discussed. So I say beware of the pay period that you select, because if you've recently promoted an employee, recently hired certain employees, it may provide misleading information in the report. It may make it appear as if there are some pay inequities or disparities, but there are some underlying reason that justifies why we're seeing the pay disparities on paper. So when choosing the pay period, you may want to take extra care in trying to select a pay period that is not misleading to the California Department of Fair Employment and Housing, because you don't want it to trigger some sort of an investigation, which the DFEH does have the power to do. Next slide. We as employment defense litigators also have some additional concerns. This new law comes with the caveat that the DFEH will protect private individualized information, and in publicizing, or I should say publishing this data, which they intend to do, they will not associate any of the figures with any individual person, companies or individuals. I don't know about you all, but I would not trust the DFEH not to inadvertently disclose information that could be traced back to the company. So that is concerning, number one. But number two, as many of you have probably experienced, if you've been involved in any sort of harassment, discrimination, retaliation complaint, as you know, the claimant has to file a DFEH complaint first, exhaust their remedies. And you as the employer or your outside counsel will then send a letter to the California Department of Fair Employment and Housing and ask for any information, any records that individual submitted. Well, that process, unfortunately, is going to exist under these circumstances as well. If in the future your company is sued for, under the Equal Pay Act or for race or gender discrimination that has an allegation that the plaintiff was not paid in an equitable manner, that plaintiff or their representative, the plaintiff side lawyer, will be able to request the data that your company submitted to the DFEH. So again, another reason why the data that you submit should really be submitted in a way that doesn't provide misleading information, that doesn't lead one to conclude that there is pay inequity when really none exists. And you may even want to consult with outside counsel, at least during your first round of submissions, so that you develop a methodology that protects the company. Next slide. And then an additional consequence that I already mentioned was also the fact that the DFEH has the power to investigate any disparities that they themselves identify. Next slide. So let's turn now to diversity on boards. This is a new California requirement. It may sound similar to another bill that was passed back in 2018 that may have affected some of you. Back in 2018, there was a bill, Senate Bill 826, and I apologize, the slide has a typo. It says 825, should be 826, that required gender diversity on boards. This is exactly the same type of bill that's now been passed, but it requires that any publicly held corporation in California achieve diversity on its boards by the following ways. A board of 5 or more board of directors will need to have at least, by the end of 2021, a board will need to have at least one individual who represents an underrepresented community. So we're talking about people of color, individuals of color, and also those who self-identify as LGBT. So end of 2021, any board must have at least one diverse director. By the end of 2022, a board of 5 to 8 directors must have at least 2 diverse directors. And any board with 9 or more directors will need to have at least 3 diverse directors. A question that has really come up in response to this law is, how do you achieve that? Does this require your company to suddenly now discriminate against non-LGBT, non-racial minorities, non-diverse individuals that are on your board, such that it's a zero-sum game where you have to remove some seats to make room for compliance with this law? It really has raised more questions than we have answers, but I do want to share some initial feedback that our corporate lawyers have shared in response to this law. So some boards are going to choose to wait and see. Some companies are going to choose to wait and see because we do expect there to be litigation. And in fact, there was a case just recently filed that says that this new law is unconstitutional. And so these challenges could continue to mount, and there could be an order issued by a court ultimately that essentially stays or freezes this mandate by the state of California. So some companies may choose to wait and see. Other companies are expanding the size of their board to make room for diverse directors and in compliance with this law, while others are taking more of a middle approach. And it's another option that your company may have, which is simply adopting a practice whereby the board member, you're turning seats within a reasonable period of time that allows you to get in compliance with these laws, with this particular law, by the end of 2021 and thereafter. Next slide, please. Just want to quickly cover what happens with respect to non-compliance, which is not a recommendation by McDermott, but ignoring this law could result in some hefty penalties. The first violation is $100,000, and any subsequent violations will be $300,000. And it's the California Secretary of State that is being authorized to issue these penalties if the company's annual filings are not reflecting compliance with this new law. Next slide, please. I do want to mention that just this week, NASDAQ, and some of you may have already seen this, announced that they submitted a proposal to the Security Exchange Commission to require listed companies with NASDAQ to have at least one woman board member and one other board member from an underrepresented group on their boards. So California may be ahead of the curve here. This may be a sign of what's to come from the exchange, for example, NASDAQ or other exchanges. Next slide. And what I have here are a list of the cases that have been filed in response to the law that was presented and became effective in 2019 with respect to gender on boards. That's the Crest versus Padilla case and the Melend versus Padilla case. And the more recent case was filed October 21st of 2020, and that's against this current law that I just told you about, diversity on boards. And these cases are being brought not just by shareholders, but taxpayers who are arguing that this law is essentially creating an unlawful quota. I did take a look at the dockets, and frankly, with respect to the gender on boards case mandate, these lawsuits have really done very little to stop the law from remaining effective. So we'll have to wait and see if there are any, if the litigation brought in the most recent Crest case will actually have an impact on whether this new requirement of diversity on boards is prevented from being enforced. Given what we've seen with the last law, my prediction is that it will be enforced effective next year. So your companies should really start looking at options to the extent that this new law affects you. Next slide. With respect to federal contractors, and if you're not a federal contractor, but you're a subcontractor, right? You're providing support to another entity that is a federal contractor. This law actually applies to you as well. It's not just applicable to the prime, but also to the subcontractors. So Trump issued an executive order on September 22nd of 2020 that basically prevents any federal contractor and subcontractor from providing any training that, according to the executive order, has divisive effects. And the purpose of this law is to eliminate those divisive effects within the military agencies and federal grant recipients. And so, for example, many companies provide training on implicit bias. That would actually be prevented now under this executive order. Next slide. In light of the fact that we're going to have a change in administration, there's a very high likelihood that this executive order will be repealed. So for those of you who are contracting with the federal government, it's something to keep your eye on in the month of January 2020. Next slide. All right, so what is your organization doing to prepare for diversity, equity, and inclusion? Following George Floyd's killing, organizations around the country started to lean into having more honest and robust conversations with their employees, with management, providing more robust training. McDermott responded by reaching out to its clients and other companies around the country. And what we did is we formed a program called Moving the Needle on Diversity, Equity, and Inclusion. It was a 3-part program, and the first part of the program involved having these small working groups, think tanks that included 10 to 15 different companies. And we had individuals from the C-suite and the general counsel's office come together and share with one another as to what initiatives their companies were putting in place, what was working, what's not working. And it was a very helpful and eye-opening experience. And what I want to do before I close my section off is actually give you some takeaways. Most of you obviously did not participate. Some of you out there may have participated in our working groups. And so without disclosing who said what or any of the specifics, I did want to, at least a high level, share some of the takeaways, because if your organization is looking at implementing policies around diversity and inclusion, I think some of these takeaways from those working groups may be very, very helpful. So with respect to recruiting and retention, here were a few thoughts. Some corporations are simply expanding or adding diverse employees to their interviewer panels with the hope that that can increase their diversity numbers across their workforce. Others are simply expanding the candidate pool with qualified diverse talent based on where they're searching for diverse talent and being more conscientious about where they're looking for diverse talent. Some companies have started using artificial intelligence in their recruiting materials and programs. For example, not just where they're recruiting, but what messaging, what language is being used in the job advertisements or in the job requisitions that will increase the candidate pool with diverse candidates and women. There's one vendor out there, just as an example, that guarantees that they can increase the candidate pool with minorities and women by as much as 15 to 20% just by using their artificial intelligence and putting out job requisitions. The idea being that if your job requisitions make it appear as if you're searching for a unicorn, you're not going to ever find that unicorn. And it also dissuades workers of color and women from applying if they feel they can't check off every single box in the job requisition. There are some companies that had actually considered establishing satellite offices in locations where the location has a diverse community and where they can pull diverse candidates into the workforce. Some companies are partnering with schools. Some of you may already do that, and particularly schools with a high number of graduates who are diverse, or predominantly Black colleges, where they have internship programs or other recruiting programs to increase their diversity ranks. In addition to that, there was one particular idea that I had never heard before, which is really affects retention. And the idea is creating a program where someone who already works for you and is diverse has the opportunity to put their job essentially on hold, which I realize this idea or this initiative wouldn't work for every single company, but it puts that job on hold while that individual gets additional training and development so that they can continue to move up the ladder within the organization. And so that was one approach that a company was considering to increase retention, not just at the rank and file level, but upwards into its management and director level roles. And then, of course, with respect to retention, we had a lot of discussion about affinity groups, mentorship programs, and how that assists in maintaining, or I should say assists, not necessarily guarantees, but helps in maintaining diverse talent within the organization. So with that, I will pass it along to my colleague so that we can now touch on our next segment.
Thank you, Yesenia. So jumping into legislative updates, the first area that I was going to cover today was some COVID updates and new laws, namely in California. So before I jump in, we have a polling question for the audience. So for California employers, have you reviewed your COVID-19 policies to ensure compliance with the Cal-OSHA emergency standards, which were effective on November 30th? So if you can vote, yes, no, or what new emergency standard, see how that comes out. Okay, so 62% said yes, 24% said no, 15% are blissfully unaware of a new standard. So let's jump into that quickly. Next slide, please. So the new law, this law was passed by Cal-OSHA on November 19th and went into effect the Monday after Thanksgiving, a special Thanksgiving treat for employers in California. What it applies to all California employees and employers, except for those employees who work from home, a work site where an employee has no contact with other people, or those employers that are covered by Section 5199 of Title VIII. What that means essentially is healthcare operations generally are excluded, acute care, clinics, med transport, et cetera. So if you're a healthcare employer, you're likely not covered by these new standards, but all other employers are. Now, realizing many employers still have most of their workforce working from home, this law is in effect as of now for 180 days, unless Cal-OSHA decides to extend it. So for employers who are thinking about having their employees return to work in less than 6 months, you should pay attention to this law and look at your policies if you intend to have employees come back to work within the next 180 days. Could you go to the next slide? So the rules that are set forth in these emergency and temporary standards are extensive. The order is 21 pages of regulations, rules, and laws. And we tried to boil it down to the basics. But if this law does apply to you, it is important to make sure you read the law, given there's a lot of very detailed intricacies within it. But essentially, the important parts are that employers must have written COVID-19 prevention programs, which ask that employees communicate COVID-19 symptoms or exposure and make it clear that they will not be subject to any form of retaliation or reprisal if they do so. The policy is also required to describe available accommodations for those who are high risk and may not want to come to work or feel comfortable coming to work. Also, the program needs to provide information about testing where applicable, and I'll get into where testing would be required. It is also required to communicate policies and COVID-19 hazards to an employee. And so if, the Cal OSHA has taken the position that many employers already have these programs in place through their illness and injury prevention programs, which are required by other state laws. But you should look at your policy and compare it to the law to make sure that your policies match up with the new requirements. One of the more onerous requirements that you should be aware of is that you have to provide notice of exposure, any COVID exposure, within 1 business day to employees, authorized representatives, and contractors who may have had exposure. And that's defined as being 6 feet of a COVID-19 positive case for 15 minutes or greater in any 24-hour period, or anyone present during a high-risk exposure period. And that high-risk exposure period is defined, it depends on whether there were symptoms or no symptoms, but it's anyone essentially between 2 and 10 days of this individual. Those are the people you have to notify. So authorized representatives, what does that mean? There's no definition necessarily in the law. We interpret it to mean union business representatives, for example, would also be included in the scope of the notice. And so one of the challenges that many employers have is simply identifying who may have been in the circle of exposure, given the definitions are so broad. The standards also require training on policies and avoidance. The regulations are very clear as to what has to be in the training. So to the extent you've done a training, say back in March, you might want to dust off your training materials and make sure that they comply with the new standards, because Cal OSHA is going to be checking, and I'll get into that in a little while. You also have to keep records that you've done the training, that you followed all of the bullet points that are in the order. Again, this becomes very important if and when an employer has exposure. Could you go to the next slide, please? In my view, one of the most significant developments in this new standard is requirements placed on employers if there's an outbreak or a major outbreak. And the way the standards define an outbreak is having a work site having 3 or more positive cases within a 14-day period, or a major outbreak is defined as 20 or more cases within a 30-day period. Once an employer falls into either an outbreak or a major outbreak within that definition, there are new requirements placed on an employer, substantial requirements, until no new COVID cases are detected for a 14-day period. So if you fall into, I'll call it the penalty box of an outbreak or major outbreak, you're going to be subject to the more onerous requirements potentially for a very long time, depending on how things develop. The significance, as soon as you're in an outbreak or major outbreak zone, you have a testing obligation. And the order says you have to provide testing at no cost to all employees during work hours. Now, us wage and hour lawyers, that's, if you can't offer on-site testing due to cost, bringing an on-site testing facility on-site can be cost prohibitive for many employers. You need to start thinking about, how do we get the employee to the testing site? How do we account for that time? How do we make sure they're paid for that time? So things to think about as you are, anticipating the potential of having to deal with this down the road. Not only do you have to provide testing at no cost, the order also specifies the cadence in which you need to provide testing. So testing has to be provided immediately after you fall within a definition of an outbreak or major outbreak, and again a week later. And then testing has to be provided at least once a week. And the reason I say at least once a week is the public health department can come in and tell you, you know what, we want you to test daily, twice a week, 3 times a week. The order allows them to order that, and you have to comply or risk penalties or shutdown. So the order says testing has to be provided at least once a week until the employer is out of the outbreak definition. Where you have a major outbreak, 20 or more cases within a 30-day period, you have to require twice weekly testing. And the testing applies to any employee who still remains at work. And so it's not, you have to, figure out a way to test everybody, but it really applies to those who remain at work. Next slide, please. The other thing that's really significant in my view about these new standards is that any exposed workers have to be excluded from the workplace. And excluded means they have to be out until they meet certain return to work criteria, also are outlined in the order itself. One interesting thing that puzzles a lot of us practitioners and many employers is that the order says an employer cannot require return to work testing. And so employers are going to have to think about what can we do to ensure that when employees are returned, we're doing so safely. And so you should take a look at your practice and give some thought to what your policies are when an employee has been exposed, have been taken out of the workplace. Do you have clear policies that match the standards that were set forth by Cal OSHA as far as return to work? The other thing that is different and special about this order is that it says that excluded workers must receive their regular earnings and benefits. We read that as essentially adding to paid leave obligations. Employers in California may be subject to the FFCRA, they may be subject to the California supplemental paid sick leave pursuant to COVID. This seems to add in both of those laws, provide limited paid sick leave, limited guarantee of benefits. This order does not provide that. It says you essentially have to continue pay and benefits when someone's out of the workforce. It does say you may use employer-provided sick leave benefits. So if you offer a sick leave policy or a PTO policy, you can encourage and require your employees to use that before shelling out additional leave. It also says that if state-provided funding is available, i.e. through workers' comp, SDI, you can apply that as an offset. But it again puts an employer in a position in a question as far as the extent to which leave needs to be paid. This order says indefinitely. Non-compliance will lead to penalties. If you're familiar with Cal OSHA, there is a wide range of penalties that are available that they can issue. They also have very clear authority that if Cal OSHA believes that the facility or work site is unsafe, they can order a shutdown, both of a work area, work site, or the facility altogether. The importance of all of this, though, is going back to the first point I made, which is you really need to go back and make sure your policies are compliant, because if in the event you have an outbreak, you have to notify the local health department. Cal OSHA will absolutely start knocking on your door, and making sure you have policies that are compliant will probably go a long way to ensuring that you will not be subject to monetary penalties or a facility shutdown. The last bullet point, the Cal OSHA has promised more guidance, uncertain as to when. This morning, right before we went live, they did issue new guidance. There's FAQs available through their website. They said in their FAQs, they would be updating their FAQs, and also they have a notice and comment period for stakeholders and are planning to have a meeting in November or December. There wasn't a specific date where employers might have the ability to participate and present as to whether or not there are issues with this order. So that is the Cal OSHA new laws. If you could go to the next slide. Piggybacking on the Cal OSHA standards that are in effect for 120 days, there's also a new law set to go into effect January 1st, AB 65, that imposes specific reporting and notice requirements on California employers. And that law is in effect for 2 years until January 1st, 2023. Quite a few of the requirements that are in AB 65 I just covered in the emergency standards that went into effect on Monday. Like the emergency standards, you have to provide notice of exposure within 1 business day. You have to, the ordinance has specific requirements as to what needs to be in the notice. Specifically, the notice needs to explain your safety plan, your disinfection plan in the event of exposure. You also have to provide notice to the local health department if an outbreak occurs within 48 hours. The outbreak definition in AB 685 is the same as the outbreak definition in Cal OSHA. Before I go to the next slide, one other point I wanted to make. I've received quite a few questions about the Cal OSHA emergency standards from employers saying, is Cal OSHA going to delay, the enforcement? When I read FAQs this morning, the FAQ essentially said, we're not going to delay enforcement. Most employers should already have illness and injury prevention programs. And so there's no relief at this point being offered to employers. Could we go to the next slide, please? The other significant, in my view, change to AB 685, prior to this new law, Cal OSHA would provide 15-day notice of a violation. So an employer would get a notice of an unsafe workplace condition, have 15 days to remedy that violation. This law changes that. It allows Cal OSHA to issue an order prohibiting use, which would essentially shut down an entire work site or work area that exposes employees to an imminent hazard related to COVID. They can also issue citations for serious violations without providing a 15-day notice. And the citation is a financial penalty, which under the statutory scheme, Cal OSHA has quite a bit of ability to determine what the appropriate penalty is. Again, emphasizing that is why it's so important to have policies that comply with the latest state, local, federal guidelines to reduce the possibility that there will be a fine issued or that there will be a shutdown. Could we go to the next slide, please? So good news is on the horizon. The vaccine is coming, and we are starting to receive quite a few questions from employers about, can an employer require it? What we're advising employers right now, the latest guidance is that healthcare employers might start to see the vaccine coming through before the end of the year. Other employees and groups of workers, we're looking probably at the first 6 months or to the summer of 2021. We're advising employers at this point to really give some thought to thinking about, as an employer, let's put aside what the law says, because the law right now, there is no specific guidance. Are we as an employer going to require the vaccine or not? And that's something that we are advising employers to start thinking about right now, because there will be quite a bit of communication about any policy, legal review, et cetera. But the first question is, do we intend to require it as a matter of policy or not? So legally speaking, there's no specific guidance on the question of, may an employer require employees to have a COVID vaccine? They just haven't issued it yet. However, we're relying on guidance that was issued years ago as it pertained to the H1N1 or the flu shot. And what the EEOC's position has been, is that vaccinations and health screenings are medical examinations under the ADA, the Americans with Disabilities Act. Requiring a vaccination as a condition of employment must be job-related and consistent with a business necessity or justified by a direct threat. There have been case law, especially in the healthcare area, where the courts have found that a healthcare employer certainly may require vaccinations. Others are more case-by-case specific. The legal concerns of requiring a vaccination if an employer desires to do so, and it's not otherwise prohibited by either federal laws, local laws, state laws, all of which we expect to be forthcoming. Employers also have to anticipate that any policy requiring a vaccination has to assume that there will be flexibility and carve-outs to comply, both with Title VII, both with the ADA and requests for accommodations. So the established law is clear that even when an employer requires a vaccination as a condition of employment, there has to be a carve-out under Title VII for sincerely held religious beliefs or medical conditions or disabilities. And that would start off the interactive process as far as whether an employer can accommodate an employee who cannot have a vaccine due to a disability or medical condition. We also have, there are also a lot of other legal issues that are at stake and that are kicking around as far as whether and if an employer may force employees to take the vaccination. The NLRA, for example, the National Labor Relations Act, for those employers who have a union workforce, the question is whether or not we would have to go to the union and engage in bargaining over whether or not, as a condition of employment, we can require a vaccination. OSHA, as you know, places an obligation on employers to keep the workplace safe. There's clearly a tension between, on the one hand, Title VII, which requires that we allow for religious accommodations, OSHA requiring that we keep the workplace safe. McDermott intends to hold a extensive discussion on this in a webinar as the laws develop. We are anticipating in the next month or two, not only will the EEOC come out with guidance, but state governments, federal government, and probably local governments will come out with their own policies and perhaps rules on this. So stay tuned, but in the meantime, we certainly recommend that employers start to give thought to, as an organization, is this a direction we want to go into in the first place? May I have the next slide, please? Before I leave the COVID portion of the presentation, one thing that we're starting to see is the fallout, and we're starting to see lawsuits, and we're starting to see, employees suing for, the result of being infected at work or having to work in a work environment that isn't safe. There are already some research being done about how do people hold employers responsible if there was a employee who contracted the virus at work. And the national survey, the results are here. 46% of the participants said that an employer should be held responsible. 41% of the participants agreed that it was an important function of juries to send a message to corporations to improve their behavior. Those statistics, as a trial lawyer, are troubling to me, that people just, say, yeah, employers should be responsible without having, the clear picture of facts. And so what that suggests for all of us is that maybe employers should consider drafting arbitration requirements for certain COVID-related litigation. And again, it goes back to what I keep emphasizing, is making sure policies, procedures, practices, training is robust, up to date with state and federal laws. May I have the next slide? Okay, this is an odd transition, going from COVID to California minimum wage, but maybe a nice departure for many. So California, as many know, has minimum wage requirements, and that these are the requirements that are going into effect January 1st. The important thing that where you have exempt employees that are making the minimum amount that is required under the exemption laws is to make sure that if you have employees that are in the $50,000 range, that you update their salaries effective January 1st, 2021, or you automatically lose the exemption status in any lawsuit or administrative claim. So the important thing is that you make sure you update your wage requirements and also the salary minimum. You know, California is also wonderful in that we also have 37 different local minimum wage requirements that all have varying dates of implementation. Some have been the increases and some have been delayed due to COVID. So you should definitely take a look at what minimum wage applies in your locality and make sure you've also updated it appropriately given the timing. Can I have the next slide? Okay, another interesting change in California law effective January 1st is AB 1947, which expands the statute of limitations for an employee to file a complaint with the Labor Commissioner's Office, or the DLSE, from 6 months to a year. So essentially what this law applies to is if an employee believes that he or she was discharged for, say, complaining about meal periods. That is a regulation that the Department of Labor Standards has the authority to enforce, that along with 48 other statutes. So not only could the employee file a civil claim under the Labor Code saying I was denied meal periods, he or she could also file a claim for retaliation with the DLSE, which goes from 6 months to a year. And so what we anticipate is an uptick in these retaliation claims, not only because the statute of limitations is broader, but also because a court is now allowed to award attorney's fees. So the plaintiff's lawyers will have more of an incentive to represent employees in these types of claims. So something to be aware of. It could result in our view, in a significant uptick in these types of claims. May I have the next slide? Okay, worker classifications. Many of you are familiar with California's independent contractor laws. AB 5 is the law that came out following the Dynamics decision on the appropriate standard for independent contractors. AB 5 had some specific carve-outs that allowed certain employees to be subject to the less restrictive Borrello common law test. In September, the governor signed an order which allowed for additional exemptions under the statute, and some of them are fairly significant. In my view, one of the more significant carve-outs are the Borrello test. The less restrictive test would apply to bona fide business-to-business contracting relationships. So if you have a company contracting with a company to provide services to one another, provided it meets certain tests, that there's a valid contract, that it's not a sham contract, and otherwise meets the Borrello test, that type of relationship would continue to be subject to the less restrictive Borrello test. The same is true with single engagement business-to-business transactions. And so the law before did not have the carve out where you have one single business contracting with another to perform a service, say for an event or a service of any type. This law expands that. There are certain factors that have to be met for the single engagement business-to-business exemption to apply, which is that there has to be a written contract specifying payment terms. There has to be a lack of control exercised amongst the two parties. It has to be a standalone event or a series of events that happens no more than once a week. And so that's good news. And then there's a variety of other carve-outs, very specific carve-outs to to the statute. The music industry and performers specifically, they're not all exempt, but most performers and certain occupations involved in creating, recording, marketing, distributing music are exempt, as are certain professional services. So if any of these apply or might apply to you, you might want to take a look at the specific exemption to see, if the relaxed standard could possibly apply to these workers. And I'm now going to turn it over to my partner, Kristen Michaels.
Thanks, Ellen, and good afternoon, everyone. I want to start by focusing on a couple of recent EEOC developments that aren't otherwise covered in our sections during our discussion here today. And we wanted to bring them to your attention, not only because they're recent, but because they generally apply to all employers. So we thought this would be just kind of a helpful discussion for everyone on the call today. So the first one that I want to focus on is the EEOC's recently distributed updated compliance manual on religious discrimination in the workplace. And it's a draft, and so it's not yet been authorized or finalized, and that is because there is a public comment period that is open until mid-December. And following that period, the EEOC commissioners have an opportunity to address any concerns that are raised as part of that comment process. But the guidance is, many of you may know that the EEOC has previously had a compliance manual on religious accommodation, but it hasn't been updated since 2008. And since that time, there's been a fairly significant number of cases on religious discrimination and religious accommodation, both at the Supreme Court and at federal appellate and district court levels. So the EEOC decided it's time to really, bring its manual up to date. Many of you also may know that a compliance manual issued by the EEOC doesn't have the force of law. It doesn't rise to the same level as EEOC regulations. But having said that, it's a really great insight into what the EEOC's enforcement priorities are. And it kind of tells you where the EEOC is going to go or what their thinking is going to be about certain religious discrimination and accommodation issues. And it's a really great summary of the case law in this area as interpreted both by the courts and the EEOC. So for that reason, it's a really valuable resource when you as an employer are trying to grapple with different religious accommodation and discrimination issues. So let me just kind of highlight, as those of you who've waded through EEOC compliance manuals in other areas know, they're usually relatively dense and long. So I just want to kind of highlight some of the features of the manual for you. So when you have an issue, you kind of know what's there. The EEOC starts their compliance manual with kind of an overview of the law, which of course is that employees are protected from religious discrimination in the workplace, that the definition of religion is broadly defined under Title VII, and that employees are protected from any discrimination with regard to their religious beliefs or observances or practices, as long as those beliefs and practices are sincerely held. Interestingly, the EEOC notes in its compliance manual that's recently issued, it's irrelevant if an employer doesn't view a work requirement as implicating a religious belief. And it's also irrelevant if most people that are of the employees or the applicant's faith view it as not implicating a religious belief. What is the important inquiry is whether, what is the employee's own religious beliefs? As long as it's sincerely held, that's really the operative standard that the EEOC at least is going to use. The EEOC, though, does make clear that generally political or economic or social or personal beliefs are not considered a religion for purposes of Title VII, but simply because there's an overlap between a religious and a political view doesn't mean that that view or that belief or that practice falls outside coverage or ambit of Title VII. As long as that view is part of a comprehensive belief, it is not kind of an isolated teaching, it will have the protection of Title VII. Next slide, please. The manual also contains, I think, a really nice summary of the typical and appropriate accommodations that employers should be considering when faced with a request for a religious accommodation. It also notes that, like the request for an accommodation under the ADA, the Americans with Disabilities Act, employers who receive a request for a religious accommodation need to engage in an interactive process about the requested accommodation. It is not a separate violation if an employer fails to engage in that interactive dialogue, but the EEOC notes that if an employer doesn't, it's going to be pretty hard to establish that they've given or appropriately not given a reasonable accommodation, and it will likewise be hard if the employer is asserting an undue hardship argument. So important to understand that. The manual also gets into an issue which I know that in my own practice, I see a lot of employers grappling with, and that is whether a requested accommodation can be denied based on grooming or dress code policies. And there's a fairly lengthy discussion about this, but in a nutshell, the EEOC is saying that, employers, just as in other areas of potential discrimination under Title VII, cannot rely on customer preferences. Here too, a customer religious preference or bias is not going to be an appropriate basis for denying an appropriate requested accommodation. With regard to the undue hardship analysis, there's also a nice discussion of the factors that the EEOC and the courts look at in determining whether an employer can establish undue hardship in this area. And the manual also talks about an issue which, again, I'm seeing more and more frequently, and that's this issue of proselytizing in the workplace. And what employers can do when there's disagreement between employees about the right to discuss and to engage in a religious practice or religious discussion, and other employees' objection to that practice or that right. And essentially what the EEOC's manual says is that the employer is going to be a very fact-specific situation, but an employer needs to balance an employee's right to engage in religious practice with other employees' rights not to be harassed, or other employees' rights to express their desire not to be subjected to religious views or practices with which they may not align. Next slide, please. Okay, so that's the first development I wanted to discuss. The second development is, it's an interesting one because the EEOC in September of this year essentially scaled back its own enforcement policies when it comes to bringing pattern and practice cases against employers. So many of you may know that under Section 707A of Title VII, the EEOC is authorized to sue employers in a pattern and practice discrimination case to combat systemic discrimination. And for some time now in the past, the EEOC has interpreted Section 707A to mean that it does not need an underlying charge of discrimination to bring one of these pattern or practice cases, nor does it have to comply with the normal pre-suit requirements that the EEOC would otherwise be charged with. And that means they don't have to have an underlying charge, they don't have to have a reasonable cause finding, nor do they have to engage in attempted conciliation. That had been their position, and of course that generated a lot of litigation and disagreement. And as of September, the EEOC issued an opinion letter clarifying that Section 707A does not give the EEOC the authority to bring a standalone claim, and that claims are indeed subject to pre-suit requirements. So that was good news for all employers. Okay, next slide, please. So I'm going to transition from one federal statute and one federal agency to another. I'm going to go from the EEOC and Title VII to the NLRB and the NLRA. And as many of you probably know, the National Labor Relations Act applies to all employers, whether or not you have unions in the workplace. And there's been some recent legislation that is that signifies that we may be seeing a lot of changes in this area to come, and also signifies a potential return to some of the not employer-friendly rulings in case law and positions that we saw under the previous NLRB under the Obama administration. And that, again, many of those rulings touched all of us as employers. So I want to focus you particularly on those types of potential developments. So first and foremost, I want you to be aware of a statute that was passed by the U.S. House of Representatives in February of this year, and it's called the Protecting the Right to Organize Act. The Senate did not act on the statute after it was passed by the House. Having said that, President-elect Biden has indicated that he supports this act. And following the election in November, many labor groups have ramped up the pressure on him, requesting that this be one of his top priorities. The act involves or proposes significant changes to both the NLRA and existing case law. Next slide, please. So there's many aspects of this law. We've tried to boil it down and summarize them for you into some of the bigger pieces of this. First and foremost, the act proposes to eliminate the right to work laws in 27 states. For those of you who aren't familiar with a right to work law, it essentially gives employees the right to choose not to join a union or pay dues to a union. Again, this act seeks to eliminate that right. The act also seeks to overturn much of the case law that has come down in the last 4 years that, again, has been in large measure employer friendly. First and foremost, it seeks to reverse the Supreme Court's decision in the Epic Systems case, which allowed arbitration agreements that mandate individual arbitration. As you may recall, the NLRB long took the position that such agreements violate Section 7 of the National Labor Relations Act. The Supreme Court held otherwise and said they are enforceable under the FAA, so we may be seeing that issue come about again. This act would, Ellen just talked to you about the ABC test that California employs for independent contractor analysis. The act would also mandate the use of that test for workers who are governed by the NLRA to determine whether they're an independent contractor. The act also would provide, interestingly and frankly disturbingly, a private right of action for unfair labor practice charges that are filed. So this would be in addition to all of the rights and remedies and the right to litigate that already exists under the National Labor Relations Act, and would also provide for criminal liability on corporate officers and directors who violate the act. And some of those fines, as you can see, up to $100,000 for each violation, can be quite hefty. Next slide, please. Other potential changes, the PRO, or the Protecting the Right to Organize Act, would seek to return to the previous joint employer test that we saw under the NLRB under the Obama administration. And if you recall, that test was one of, if an employer has the potential to indirectly control the terms and conditions of employment of another employer, or even if it has the potential to do that, then under the standard that was employed during the Obama era, that employer would be the joint employer of the secondary employer. And during the Trump NLRB, the NLRB returned to the previous standard, which was there has to be some type of direct control in order for there to be a joint employer finding. Many of you probably recall how difficult it was to really figure out how to employ the test under the Obama administration. This is what the PRO Act would return us to. And then some of the other cases that we saw overturned in the last 4 years, many of you may recall the Purple Communications case, which held that employees could use a company email system for purposes of union organizing or other Section 7 rights. That decision was overturned a couple of years ago. This act seeks to reinstate the right of employees to be able to use company email systems, except in very limited circumstances. Next slide, please. Okay. Other notable NLRB developments. This really goes to my comments that I made just a few minutes ago. Under the previous NLRB during the Obama administration, all of us as employers spent a lot of time going line by line through our employment policies, through our employment handbooks, because the NLRB had taken a very expansive view of what types of provisions in our policies and our handbooks were violative of the NLRA. For example, the NLRB often found statements that said employees could not engage in abusive conduct, or they had to act civilly towards their coworkers as being overbroad, as potentially violative of Section 7, because employees could misunderstand that to mean they couldn't engage in Section 7 rights to discuss unions or disagree about employment policies and procedures. During the course of the last 4 years, in the most recent NLRB, a lot of those rules that frankly confused us all and made us all scratch our heads as to how we write these policies and write these handbooks to comply with the NLRB's new standards have been scrolled back, and the board has taken a much more practical view of these types of provisions and handbooks, and have found, for example, that employers can have social media rules that say that employees have to act civilly when making public statements about the employer. This NLRB has found that a lot of confidentiality policies that previously had been ruled unlawful as being overbroad are generally, unless they're precluding employees from talking about wages and compensation and terms and conditions of employment, are generally okay. And the NLRB has also modified its standard for determining when employers can discipline employees for making abusive or offensive statements in the workplace. There had been 3 different standards that the NLRB was using, which again was very difficult for employers to wade through to determine at what point can we discipline employees for making statements which would otherwise be subject to discipline. The NLRB more recently has said, look, even if this involves Section 7 rights or protected activity, if an employer would otherwise discipline an employee for making such statements, for example, if an employer can point to other employees who've been disciplined for the same type of conduct, then it's not a violation of the NLRA for disciplining an employee, even if they're making the statements in the context of concerted activity. So what we've seen is really kind of a return to a more employer-friendly type of standard, type of review by the NLRB. Of course, as you all know, as the political winds are changing, many of these developments may get set aside, may get modified or reversed. Not likely during the first 9 months of 2021. The reason for that is because that it's not until August of 2021 that President Biden can appoint a new member of the NLRB. Bill Emanuel's term is up in August. And so at that point, there will likely be a more pro-union majority on the board. But just a note to all of you that while at the moment we are operating under some more employer practical type of standards, we have to keep very vigilant because these things could quickly change in late 2021 and later. Okay, next slide. And then finally, this is an issue that's come up, frankly, in a number of areas, even on some of our past webinars. But one of the questions has been, at what point can an employer discipline an employee for engaging in certain types of political advocacy? At what point does that run afoul of, at least here, the NLRA, and there's certainly state law provisions on this as well. But recently, the NLRB said that political advocacy or social reform type of advocacy is not protected under the NLRA unless it's related to some type of workplace issue or term and condition of employment. So in this particular case that you see on the screen in front of you right now, the NLRB said, look, interestingly enough, the employer in this case was a union, and they had disciplined their employee who filed a charge and challenged that decision. But the NLRB essentially said this type of political advocacy had nothing to do with an issue that the employee was concerned about in the workplace. So therefore, it's not protected under the NLRA, and the discipline in this particular case was, it was discharge and it was appropriate. Okay, and with that, I'm going to turn it over to my colleague. I think Elvira is next. Oh, yeah, no, that's fine.
Did you have one more slide, I think?
No. I think we're, to keep us on time, I think I'll turn it over to you, Elvira.
Okay, great. Well, it is time for a little bit of audience participation. We have our next poll. Nora, if you don't mind putting that up for us. Okay, question, tricky question. Have you updated your handbook policies for 2021 yet? Yes, of course. I'm a STAR student. Working on it. We'll be reaching out to McDermott soon, or not yet. Okay. So most of you are in progress. So this is a timely slide. Hopefully we'll have some helpful updates for you to implement. Before I get started, next slide, please. We will be circulating the presentation afterwards, so you don't have to worry about getting every detail about the updates to the policies. We really want you to take the main takeaways of why these changes are important and what you can be doing to prepare your workforce to handle these changes. So with that in mind, I'm going to switch to a little bit of story time and tell you how this plays out realistically in practice, because I think we're all very well versed to update our handbooks, update our policies. We work hard to make sure that everything is up to date. But then where the rubber hits the road is really this next step in making sure that our managers, our supervisors, our team members that are dealing with requests day in and day out, and maybe not even formal requests, or employees aren't going through the formal processes of requesting leaves, are well equipped to provide answers that are aligned with our policies. Because we can have the best policies, most up-to-date policies, but if we're not providing the right information and training our teams, it makes things a little bit more complicated. So I'll tell you a short story. It has a happy ending. We had a case with a client we've worked with for a long time. They have great policies. They work very hard to keep their policies up to date. In most instances, their policies are more generous than the law even requires. And we had a situation where an employee came up to a new manager, and I hesitate to say it was even a request, but said something along the lines of, I might need to take some time to go help take care of a sick parent. And the manager, it was during the day, the manager said, okay, well, we'll see. What happened next? The employee took that as a rejection of a request for a leave. And later down the line, we got hit with a lawsuit. Happy ending, we were able to get a full dismissal, a full victory on a motion for summary judgment. Yes, in California, it does happen. But it was a really important lesson, because even though the policies were buttoned up and the company would have been more than happy to provide the time off, and the employee even got the time off, at that critical moment, the manager could have probably done a better job either directing the employee to reach out to a designated person in HR or who handles or administers that type of leave, or been a little bit better versed about what the policies were in order to provide a more fulsome answer about what the employee's options are. So the main takeaway here from these slides, I hope, will be, yes, very important for us to make sure our policies are updated, but we all need to be going the extra step to make sure that the people who are administering the policies, who might be getting the questions day in, day out about the policies, are being trained about how to properly respond to employees and know what the updates are, because there are some expansions in what leaves are now available to employees that are going to be different maybe than what people are used to or have been dealing with in the workplace for many years. So without further ado, let's get to these changes in California. So in California, we've been lucky that the California version of the FMLA runs pretty parallel to the FMLA. So the FMLA policies typically cover what is covered under CFRA. That is changing, okay? So what are the big key differences now? CFRA is going to be applicable to more and more employees. Now it's only 5 or more employees in California. We're taking away the geographic restrictions, so there's no requirement that employees be within 75 miles of the work site. There was also I don't want to say exception in the rules, but if both parents worked for the same employer and they were taking time off for baby bonding leave or for purposes to take care of a placement of a child, that leave was capped at 12 weeks total. Now both parents are eligible for potential leave, so there's more time available for people to be taking leave. And we're also seeing that a lot of the definitions are being expanded. So what is a family member? Who qualifies as a child for purposes of leave? A lot more people are going to be eligible for leaves under the changes to CFRA. And most importantly, these changes are different from what is currently being provided for by FMLA. Next slide, please. These are some of the definitions. Like I said, you'll get the slides, so I won't go into every detail, but also want to highlight that there is now military exigency leave that CFRA covers. And so there's a protected leave for military reasons, not just for yourself, but for a spouse, a domestic partner, a child, or a parent in the U.S. Armed Forces. And this is also different than what FMLA provides. Next slide. Previously under CFRA, if you had an employee that was salaried and was within the highest paid 10% of the employees within 75 miles of the work site, there was an exception to reinstatement that if the employer could show that refusing to reinstate the employee was required because of hardships to the business, they weren't required to provide reinstatement. And that exception is gone now. There is a requirement for reinstatement under CFRA. Next slide. Before we go to KinCare, one more thing I wanted to mention. We talked about how now there are differences between CFRA and FMLA. Another reason that's important is because previously, because the leaves would run concurrently, we knew how much leave a person could take. It would be presumably capped at 12 weeks. Now, because there are differences under CFRA protected leave and FMLA protected leave, it's conceivable that one employee could get up to 24 weeks of protected unpaid leave in California, which is double the amount of leave that was previously being provided. So on top of all the COVID leaves and all of that, be aware that that timing is now in play based on the differences between CFRA and FMLA. KinCare. So for those of you in California employers, you're aware that we have our paid sick leave and we also have KinCare. And this is important because there's differences in between the family members that an employee can use time for under the paid sick leave law and the KinCare leave law. And previously there were some questions from employers, well, how do we track the time that employees are taking to make sure, whether the time has been exhausted? Employee could conceivably exhaust time under paid sick leave, but still have KinCare time to use. And what has happened under AB 2017 is there's been an amendment and a clarification that it's up to the employee's discretion on how they're designating paid sick leave or KinCare. And that's designed to make sure that an employer doesn't erroneously deplete the employee's leave that they might have available still. So it's important just to make sure that your policies note that it is an employee's choice to designate. If you have more comprehensive policies or if you don't distinguish, this might not be an issue for you, but to the extent that you will get questions about it, it's important to be aware that this is now an employee's choice and an employee's exclusive right to designate what type of leave they're going to be taking. Next slide. So a little bit more on military leave. Now we've added another category to paid family leave. This isn't just a protected leave. This is actually leave for which employees can receive payment. And it adds military member to the definition and expands the reasons under which this paid family leave can be taken. But it also allows for the employer to require a little bit additional information to substantiate such requests for leaves. Next slide. And this is a little bit of a national trend we're seeing. We're going to talk about New York in the next few slides, but expanding protections for crime victims and what the definition of a crime victim is and protected leave that employees can take under those protected leaves. So under existing law, there are certain reasons that a employee can take time off if they've been a victim of a crime. And now what we're seeing is that the definition of victim has been expanded, and also the type of documentation that an employee can provide about their need for leave has also been expanded as well. What has it been expanded to? Well, it's for anything that had the potential to cause a mental injury or a physical injury. It's if a family member was deceased as a result of a crime. And it also allows for employees to get protected leave and time off for counseling and psychological services in order to deal with any ramifications of crime or abuse. So again, expansion, and we want to make sure that our supervisors and managers are available and aware to be able to properly grant leave and to guide people on the fact that they do have this leave available to them. Next slide, please. Okay, so we've all been, for the most part, at least for some amount of time, remote working and also dealing with administering remote work for our employees and our teams. And the EOC has updated their guidance on remote work and on the effect that remote work during the pandemic will have potentially on requests for reasonable accommodations going forward. So logically speaking, the question is, okay, well, if you were able to provide for remote work and provide that as an accommodation during the pandemic, is that evidence that a request for remote work in the future is a reasonable request, and it's a request that an employer should grant as a reasonable accommodation? And what the EEOC has said, well, maybe. It could be a trial period. And I think logically that kind of follows, but still it's important for employers to be aware that whatever that they implement during these COVID times, courts and federal agencies are going to be looking to see, well, if you were able to do it then, perhaps this is a reasonable accommodation that you can be using for employees going forward. Next slide, please. Next. So in California, we have a lot of our entertainment industry clients, and there's two important changes there in terms of training. I'll touch on them briefly. There's always been a training requirement for minors in the entertainment industry, but there is an additional obligation now that for this training, parents of the minors have to provide a certification to the labor commissioner that this training has taken place. So we want to make sure that that paperwork is being taken care of. If we're doing the hard work of doing the training, we want to make sure that we follow up on the next step to certify that it's been done. Next slide. And mandated reporters. So this is a topic that is more common in our healthcare industry, in our schools, the idea that there are certain mandated reporters to mandate suspected or observed child abuse. But this is being really expanded to businesses that employ minors. And there are questions about who would be the mandated reporter and who in the company is going to have the responsibility for receiving updated training and also providing the mandated reporting requirements. Essentially, we have to wait and see a little bit. We don't have our crystal ball fully formed about how it's going to play out, but essentially, employers need to be training employees on identifying and reporting child abuse and neglect. And this is something that we've been advising clients to put into their supervisor trainings and the harassment and workplace respect trainings that we already do. But there are substantial fines for failure to making a required report. And this is something that not all employers are aware of, that they need to potentially be adding to their trainings. Next slide. New York. All right, so Ellen spoke to you about California minimum wage increases. New York is also experiencing their minimum wage increase. I want to make sure that we're implementing that, that our payroll companies are making sure to put that into effect. Next slide. Tip credit. So previously there had still been an allowance for partial tip credit in New York. That's being done away with effective December 31st, 2020. It's going to affect about 70,000 employees. There is still an exemption for the hospitality industry, but otherwise employers are going to be now required to pay all employees their full minimum wage and not rely on any partial tip credit. Next slide. So New York City is also making changes to their sick leave policies, and it's doing so to align with the state sick leave policies. And the changes really fall into 3 buckets that are important. It's the number of employees that employers have. There are changes based on that. There's the changes about whether leave needs to be paid or unpaid, depending on the number of employees. And there's also some documentation and reporting requirements that are particularly important in order to provide employees with knowledge of how much sick leave they have. And that's something that's going to be needed to provide it for them on their pay stubs and in other documents. Next slide. We talked about this when we were talking about victims in California and the protected leave there. New York is tracking that. There's an expansion on what paid sick leave can be used for, and it tracks that same victim of sexual offense, stalking, or human trafficking. That's also going to be protected sick leave now in New York. Next slide. This touches on the details of the additional changes. I won't go through all of them since you'll have the slides. But I do want to touch on the last slide, please, on this topic. And that's about the employer reporting. There's requirements as of October 30th, 2020 and November 30th, 2020 to be able to provide an updated policy to employees and also to provide the updated balances and accruals. So I want to make sure that we're getting those out to employees because there are now also enhanced penalties for not complying with the sick leave policies in New York City that were not previously a part of the law. So that's next slide, please. In addition to the reporting requirements to employees, there's a record keeping requirement for 6 years. And again, like I mentioned, there's new penalties up to $15,000 for a pattern of violations by an employer and up to $500 per quote unquote aggrieved employee. So there's some real bite to this law if we're not in compliance. And I get to pass on to my colleague, Chris, who's going to talk to you a little bit about case law.
Well, good afternoon, everyone. I wanted to run through some big cases that have come out either this year or will be coming out sometime next year. And the first one I want to talk about is the Naranjo decision, which was a decision that was decided by the California Court of Appeal in September of 2019. It gave a very favorable ruling for employers in the sense that it was an unanswered question of law as to whether meal and rest break premium payments constitute a wage for the purposes of denoting such items on a wage statement or something that could trigger waiting time penalties if unpaid or owed meal and rest break premiums had not been paid to a terminated employee at the time of termination. This was certainly a claim that the plaintiff's bar would always latch onto. Is not only would they try to bring claims for meal and rest breaks, they would then have derivative claims for wage statement violations and waiting time penalties that would drive up the potential value and exposure of these lawsuits. And fortunately for employers, the California Court of Appeal said, no, these type of payments are premiums and not wage payments that would trigger violations to these derivative statutes. Well, now we got to hold our breath a little bit because that ruling was sent up to the California Supreme Court. That is supposed to get decided sometime next year. We're certainly going to keep track of it for you. One thing that I think a lot of employers could at least feel somewhat confident is that the California Supreme Court had the opportunity to depublish the Court of Appeal opinion, which would effectively make it irrelevant law for the purposes of what status quo would be until the court decides one way or another whether or not to overturn the decision. And the California Supreme Court decided to abstain from depublishing the decision. So as it stands, the Naranjo Court of Appeal decision is currently citable law for us defense attorneys. And we believe that the California's Supreme Court's decision to abstain from depublishing it suggests to us that they are probably going to affirm the decision. But we'll keep our fingers crossed and hope that that's the case, and we'll keep you updated in that regard. Can we go a couple more slides up to the Walmart case? There we go. So Magadia is what I would say is a bad decision for employers. This case was a lawsuit that was brought against Walmart, and a lot of employers have a practice of paying out non-exempt employees a bonus, whether that's a quarterly bonus, a weekly bonus, but they would pay out a bonus that's oftentimes tied to either productivity, and that means that such bonuses, to the extent that they are non-discretionary, need to get reincorporated into the regular rate, which means that overtime payments would need to be adjusted retroactively for those employees who receive such bonuses. Fortunately, Walmart was complying with the law, and they were doing that, and they were recalculating the regular rate for overtime payments that were paid over the course of the duration of the bonus. So for example, if it's a quarterly bonus, Walmart would go back over the term of the quarter and reallocate the bonus amount paid and to recalculate the regular rate for overtime purposes, and then make a retroactive overtime payment to the employees. They were, for all intents and purposes, doing everything necessary to comply with the law. The plaintiffs argued in this case that when Walmart was making those payments, on the wage statement those payments were made, there was a line item that effectively said overtime INCT, basically denoting that the payment on the wage statement was for retroactive overtime payments that occurred over the course of the quarter. They did not put next to that overtime payment, retro overtime payment, the amount of hours that was associated with that payment. And so, nor did they put the hourly rate that was associated for that payment. They were simply putting the total sum in connection with that payment. The plaintiff's bar was arguing that this is a violation of Labor Code 2226, which effectively says that there needs to be sufficient information on the wage statement for the employee to figure out whether or not they were paid correctly. And they couldn't reverse engineer the bonus payment to figure out if it was calculated correctly. And for that, they were argued to in this case, it was the Northern District of California, that this constituted a violation of Labor Code 2266, and therefore they were entitled to penalties under the Labor Code and under PAGA. Interesting to note that there was a California Court of Appeal a few years prior that was presented with the same question. And they said that what Walmart was doing does not constitute a violation of law. Unfortunately for Walmart, that California Court of Appeal decision was unpublished, so they could not rely on it in their case. And in their case, the judge agreed with the plaintiffs and said that that was a violation of law. Let's go next slide. And so what that meant, Walmart's a massive company, and so that yielded $48 million in statutory damages and a potential exposure of $54 million in PAGA penalties. Obviously, that's a tough pill to swallow for any employer, especially when they were, again, making a good faith effort to comply with the law and by doing the retro overtime payments. So what has been determined is now Walmart is challenging the decision and is taking it up to the Ninth Circuit to figure out whether or not there is any way to either reduce the reward or make a determination that the California Court of Appeal would previously determine that it wasn't a violation, but it was unpublished. If there was any way for this decision to get overturned. The oral argument had just happened a couple of weeks ago. We would expect to see a decision sometime early next year. But for those employers who are doing retro overtime payments, certainly you want to keep a close eye on this decision and maybe take a look at your wage statements to see if you are denoting the hours associated with the with any sort of retro overtime payment. Next slide. So Farah versus Lowe's Hollywood. Again, this is a Court of Appeal decision that was a favorable decision for employers, but we need to hold our breath to confirm that it still gets upheld. In this case, there was at issue was whether or not the employer who was actually making meal and rest break premium payments to their employees was whether or not the rate at which they were making said payments complied with the law. What the employer in this case was doing is if they had an employee who, say, for example, was paid $15 an hour, they were paying any sort of meal and missed meal and rest break premiums at $15 an hour, which was their base rate. They were not taking into account whether or not if they were making any sort of bonus or incentive payments, whether or not, and obviously as I just described, those such payments would effectively change the regular rate of pay for that employee. They were not paying out the missed meal and rest break premiums at the regular rate. Instead, they were just paying it out at the base rate. And the rationale that they were using to support their conclusion is in the overtime statute, it specifically says regular rate of pay. But in the meal and rest break premium statute, it says regular rate of compensation. So the slight difference in terminology, they argue to the California Court of Appeal, suggests that there should be two different pay rates at issue. Court of Appeal bought the argument and said, yes, correct. Employers only need to pay the missed meal and rest break premiums at the base rate of compensation, not at the regular rate of compensation. This is something that could have seismic implications if the California Supreme Court was to overturn, because that certainly is going to tip off the plaintiff's bar to basically institute a landslide of lawsuits, because in our experience, most employers do make these missed meal and rest break premiums at the base salary. So it's something certainly to keep an eye on. And we will expect a decision in this regard sometime in 2021. Let's go to the Bernstein versus Virgin America case. So this case is actually a bad decision for employers, and we're hoping that this gets overturned. This decision is pending before the Ninth Circuit. In this case, Judge Tigar in the Northern District effectively refused to consider certain arguments by Virgin America that potentially could have got them out of liability altogether. His basis for that was that the arguments were untimely and late, and therefore waived. And in that regard, he affirmed, he was then led to issue a ruling against Virgin America that resulted in it being liable for up to $77 million. One of the things that is of importance in the decision is that there's PAGA. If you don't know, I like to refer to it as the Wild Wild West. There's not a whole lot of controlling decisions or citable decisions as to how the penalties are to be issued, how much is to be reduced. Judge Tigar in this decision, he ended up reducing the total potential exposure from the PAGA penalties by 25%. And he gave a pretty well-reasoned rationale as to why he was reducing it by 25%. I would have hoped that he would have reduced it to zero, but he considered why that the Virgin America's argument as to why zero would be appropriate, but he ended up not going that far. We're hoping that the Ninth Circuit will potentially build upon some of the arguments that were made by Virgin America and potentially come to a more beneficial ruling for our clients. So we'll keep you guys posted in that regard. Next slide. Kim v. Raines was a, I like to think that the plaintiff's bar thinks that this decision is more favorable for them than it really is. This was a decision that was handed out earlier this year by the California Supreme Court that effectively said if an individual decides to settle his individual labor code claims, that doesn't revoke his ability to have standing in a live PAGA dispute. In my view, this is a pretty narrow circumstances. More times than not, when you see PAGA claims, you see them in connection with class action claims. One thing that the Kim v. Raines did not do is there is a decision that is, I believe it's from 2009. It's called V. Akers, and essentially what that decision says is if you settle a class action, the doctrine of collateral estoppel applies, and you can't relitigate it, any of the claims that were at issue in that class action in any subsequent litigation. And so that the California Supreme Court specifically considered that decision, and it did throw a little shade at that decision, but it did not overrule it. And that's important because in practice, more times than not, you're going to have a class action and a PAGA claim filed together rather than just an individual claim and a PAGA claim filed together. In this particular context, what happened was there was an individual claim who was being adjudicated in arbitration. They had a PAGA claim that was pending and stayed pending resolution of the arbitration. The arbitration resolved, but it carved out specifically any resolution of the PAGA case. But then the employer argued at the trial court level that because he's settled the labor code claim, there's nothing for this PAGA claim to resolve. The Supreme Court said settling doesn't necessarily mean, the purpose of PAGA is basically to enforce compliance with the labor code, and settling doesn't change that fact. It doesn't resolve the fact that there was a violation that occurred in the first place. and the collateral estoppel doctrine didn't apply here because it was carved out of the release, and it didn't concern a class action that was needed a settlement to get judicially approved by the judge. So it's just important to keep in mind that if you are having a PAGA dispute with an individual, to be strategic about how you go about settling the case to ensure you're getting the most bang for your buck and aren't going to be having to deal with any sort of spin-off PAGA actions moving forward. Next slide. The Frecklin versus Apple decision is also a pretty big, well, it will likely lead to an uptick in litigation. This decision came down by the California Supreme Court in May that effectively said employers who mandate their employees to go through bag checks, that time is compensable time and needs to be paid. It's important to note that it has to be a bag check or security check that is controlled by the employer, which is a lot different than, say, if you're in an organization that works, say, for example, at the airport and TSA runs the bag check, something you don't have control over. That is still something outside of the scope of this decision. But if you are an employer who does have your employees go through bag checks, it's important to have what I would argue the best practice would be to put a time clock right before they go through that bag check, so it ensures that such time is being compensated for. Before I go to other cases, I wanted to make sure that all those who are in need of New York CLE, the code for New York CLE is green 3. Green 3. So I wanted to make sure you guys got that before we wrapped up. So there's a couple of other cases that I wanted to bring out that have some importance for some of our clients. One is Ashley Judd versus Harvey Weinstein. This decision came out earlier this year, and effectively it said that for certain individuals who work in the entertainment industry or any other context where there's a direct business service professional relationship between two individuals, that there's a potential for, it just effectively provides an additional avenue for claimants to bring a sexual harassment claim. Why this case and had a lot of import is the California Civil Code 51.9 governs potential claims when there's an inherent power imbalance. And it also had a longer statute of limitations available to those claimants who are suing under the statute. Since, as this case was pending, there was some changes under California law to FEHA that effectively expanded the amount of time for somebody to be able to bring a FEHA claim. Essentially, they now have 3 years to exhaust as opposed to what was previously 1. And so Ashley Judd in this particular case was just using this statute to be able to, which her claim would have otherwise been time barred, but for the application of this statute. So it's just important to know that there are other ways beyond just FEHA where individuals can potentially recover for sexual harassment claims. Next slide. For those of you in the transportation industry, this is the big case that everyone is watching, especially if you're in the trucking industry and are covered under the Federal Motor Carrier Safety Administration Act. Short story is there are hours of service rules under the FMCSA that have been deemed to preempt California's meal and rest break rules. And this has been a big shield for employers who are in the trucking industry and to be able to defend against meal and rest break lawsuits. There was a preemption order that was issued that not only said hours of service rules preempt moving forward, but also they preempt that preemption order applies retroactively. So any current lawsuits or that were in effect, basically it took those cases out of that court's jurisdiction, and basically said, and resulted in a lot of dismissals of lawsuits. This case has been appealed to the ruling of the FMCSA as to their preemption order, and the scope of it is currently being litigated before the Ninth Circuit. They're taking the position that it's overbroad, not only with regard to its ability to apply retroactively, but also whether or not there's any merit to the rationale as to the hours of service rules being at odds with California's meal and rest break rules. There was recent argument in this regard. We have our fingers crossed that this will be upheld by the Ninth Circuit, as this is certainly a favorable ruling for those trucking employees, and we'll keep you up to date as we hear things. I'm sure you'll see an alert for us. I know that we're near our time. I want everyone to know that if you have any questions, any inquiries, that please do not be shy. You have all of our contact information here. We're here to help. We would love to help you on any of your matters. And we hope you guys all have a wonderful and safe holidays.